It's my very great pleasure to welcome you all here to this wonderful celebration, to listen to Neri give a talk. My name is Sarah Biddulph. I'm the Director of the Asian Law Centre. And this seminar today is co-hosted by the Asian Law Centre, by the Centre for CILIS and IILAH. So three of the research centres in the law school. Before we start, let me acknowledge that we are today having this gathering and sharing Neri's experience on the unceded lands of the Wurundjeri people of the Kulin Nation. I pay my respects to their elders, past, present, emerging, and note that we in Victoria, with passage of the Statewide Treaty Act, have taken the first step of the many that we need to take to show our respect, reconciliation and engagement with the First Nations of this land, whose elders take responsibility for law and land. And so it's with my greatest delight to say that Neri hasn't aged at all. I thought him 20 years ago. But I'm not allowed to say anything about you because my very pleasant task now is to invite my friend and colleague, Tim Lindsay, who's the Director of CILIS, to come and introduce Neri and to set the show in motion. Thank you.
Thank you so much, Sarah. As everybody here knows, Dr. Neri Colmenares is a leading human rights lawyer and law reformer in the Philippines. He was a key figure pushing for Philippine membership of the International Criminal Court. He was among the legislators who passed the Philippine Act implementing the Rome Statute, making that possible, and I might add, persuading the President to approve that as well. As I think you also know, he is currently counsel to families of the victims of former President Rodrigo Duterte's war on drugs, the hundreds of people killed through extrajudicial killings as part of that campaign. Those families have, with Neri's leadership, arrested and charged former President Duterte with crimes against humanity in the ICC, and Neri is representing them at that trial, most recently resisting a bail application by Duterte's team of lawyers. In 2020, Dr. Colmenares, I'm loving saying that, I supervised Neri's PhD studies here for 3 years, and at the end of the third year, he had the audacity to get elected to the Congress in the Philippines. And I've always thought of him as the one who got away. So you can imagine I was probably a little bit happier, even than Neri, that he got his honorary doctorate yesterday. So in 2020, Dr. Colmenares was awarded the International Bar Association Human Rights Award for outstanding contribution by a legal practitioner to human rights and continuing determination and advocacy in the face of greatest adversity. And that adversity, of course, also included being the youngest political prisoner jailed under President Ferdinand Marcos's rule, during which time Neri was tortured. Neri was also the recipient of this university's first human rights scholarship in 2001, and that scholarship has continued on since then, still being awarded. Neri was the first to receive that, and that's what led him to spend those 3 years here in the law school. Leaving us for Congress, he became a 3-term legislator and senior deputy minority leader as well. And as a congressman, he was the main author of important human rights laws, including the anti-torture law, the anti-enforced disappearance law, a reparation law for human rights violation victims. But he also implemented a whole range of other important pieces of legislation, for example, to assist the disabled and poor and marginalised communities. He's played a central role in anti-corruption movements in the Philippines, including the well-known pork barrel controversy, and He was public prosecutor in an impeachment trial that convicted the Chief Justice of corruption. And I think you can all see just from that brief summary, which leaves out a lot, how proud we are of all that Neri has achieved and why we're so desperate to give him a doctorate. So we now own him. Neri, I want to thank you for accepting that award and for coming back to join us again in this reunion or deja vu, whatever you want to call it. And we're looking forward to hearing you explaining to us exactly what is going on in the case of Rodrigo Duterte, what has happened, what led you along this long road to The Hague, and what you think will happen as the trial unfolds. Let's make Neri welcome.
Thank you, Tim. It's been a long time since I was here as a student many years ago, but it's great to meet friends and colleagues in the university, and of course the friends from the Filipino community and the noisy Australians who visit the Philippines during the time of Marcos who are here. So thank you so much for this, for attending the forum, and at the same time for the honor of being admitted to the Doctor of Laws honoris causa. So the topic is assigned to me was on the case of Duterte. So I wasn't interested in the ICC initially. My interest before was on universal jurisdiction. Why was I interested in universal jurisdiction? Because in 1986, President Ferdinand Marcos fled the country, went to the US, and we were thinking, do we get justice here? How can we get justice from Marcos at the time? Thousands were killed, thousands imprisoned, tortured. Well, I was 18 years old when I was arrested and tortured, mainly because I was demanding that the government reinstate student councils and school papers. An innocuous demand because Marcos banned all student councils and school papers when he imposed martial law. But you're tortured, and then I spent 4 years in prison for that. I didn't kill anybody. I didn't steal money or anything, public funds. So we were thinking, could we still get justice here? Well, we did get justice in a sense when human rights lawyers, and that's good, from the United States, found this obsolete, should we say, obscure law, the Alien Tort Claim Act. It's a 1879 law way back in the US Judicial Code, which simply says that an alien may file a civil action in a district court which has jurisdiction over violations of the laws of nations and treaties of the United States, but for tort only. So that was basically it. And we used that against Marcos. It was used before. It's so archaic, it used the old term for international law of nations. It was used actually in the case of Hilartiga versus Peña Erala, when the Paraguayans in the US filed a case against 2 torturers from Paraguay. And then many of us followed it, was I think used in the Chavira and so on. So we filed the case, and we won the case. After so long, a lot of struggle there, the US court granted or gave us one of the biggest human awards during that time, an estimated later on total to about $2.1 billion. So we were given that, but instead of me using that money to buy you all, whatever you want to eat right now, we couldn't have it because the execution was very difficult. They managed to store and hide ill-gotten wealth from us. And by the way, they still have it. That's why they had a lot of funds in the last elections. That was our analysis there in the Philippines. But in any case, so we're thinking, because we cannot get justice through through the Alien Tort Claim Act. We need a universal jurisdiction case. Was the Alien Tort Claim Act a universal jurisdiction case? In a sense, yes, because it tried a case where a Filipino violated the rights of another Filipino in the Philippines. And there's no nexus at all with the US courts. But it was tried, but it was only for civil action. So we're looking for the criminal part of sanctions to dictators like President Marcos. It came about, of course, with the ICC. The ICC came about and we're saying, oh, this, we can have jurisdiction, universal jurisdiction, that even if he fled the country, we can still have him. Of course, it's over for Marcos because the ICC was only entered into force in 2002. But at least for the future dictators and human rights violators, maybe we can get jurisdiction there. But it was really difficult, especially in Southeast Asia. Southeast Asia is the Waterloo. In fact, Asia is the Waterloo of the ICC. When only 9 countries in the entire Asia signed up for membership with the ICC, lower than Africa and many other regions. In Southeast Asia, 2, only 2. Cambodia and East Timor-Leste are members of the ICC. And I remember in 1999, or was it 2000 maybe, to 2001, we were campaigning for Indonesia to sign up with the Rome Statute. And we were there, and I got to meet, some of us, human rights ICC advocates, we got to meet Abdurrahman Wahid. And when we met him, he was president of Indonesia then, I said, Mr. President, can Indonesia sign the Rome Statute? Indonesia, you have a big role in Southeast Asia. You're considered one of the leading countries here. Maybe with your example, we can sign the ICC. And at the time, they just overthrew Suharto. So I was thinking, the new president may be amenable to human rights rules and principles. But then he answered me and said, no, Indonesia will not sign the ICC. Why? Because the law of New York cannot be the law of Jakarta. That's simple. And I said, if this is how our leaders in Southeast Asia think, then I don't see any hope at all that the Southeast Asian countries will have that. Of course, there are various reasons they will use. In Thailand, they would use the royalty. We can't sign the ICC because our king will be under the jurisdiction. But I said, well, look, Australia is a queen, right? But you signed up to the ICC, so I don't see any reason. But anyway, so we have that. But in the end, we had a sigh of relief when President Joseph Estrada signed the Rome Statute on December 27, 2000, a few days from the deadline. And there's a side story on how and why he signed it, but maybe that's for another forum or in the question and answer, but he signed. Our problem was when he signed on December 27, he was overthrown 20 days later. On January of 2001, he was replaced by Gloria Arroyo, who refused to transmit the signed treaty to the Senate. And in our constitution, in the Philippine Constitution, there is a need for a Senate concurrence in the ratification for a treaty to become effective. So we were not members of the ICC, despite the fact that we signed the Rome Statute. That was the time when I was here in Melbourne. And I think as Melbourne University, Melbourne Law School invited me to give a talk on the Alien Tort Claim Act, because I just appeared before the district court in Hawaii to argue the case of human rights violations victims. Of course, I was one of those 10,000 human rights victims who filed a claim against President Marcos, and the Melbourne Uni, Professor Tim Lindsay in particular, invited me to come over, and I discussed the case, I delivered a paper, and then they offered me why don't you study here on the ICC in the Rome Statute? So that's how it started. I started here, but my focus, after a few changes, you know how dissertations are, after a few changes in the title and the thesis topic, I said, look, if we're not members of the ICC, can we go around an uncooperative president by passing a law that will implement the Rome Statute despite the refusal of the president to sign the Rome Statute. So that's where I focused my studies here, crafting a bill, a law that will implement the ICC. But despite the fact that I was probably ending that research in a sense halfway with that bill, I I had the audacity, as Tim said, to run and win in a seat in Congress, the Philippine legislature. So I had to stop my studies here. But while it stopped my studies here, it also gave me an opportunity to help or contribute to the passage of that law. In 2009, I was one of those legislators who signed and voted for the approval of the Republic Act 9851, which is basically the Philippine Act on crimes against international humanitarian law, genocide, and crime against humanity, practically aimed at implementing the Rome Statute in the Philippines. So we sort of bypassed Gloria Arroyo there. In 2011, the new president, Aquino, transmitted the treaty and we became members of the ICC. Little did I know that in 2016, a certain president would sit and practically trampled on the rights of many Filipinos to the extreme. All presidents, of course, there are always records of human rights violations, but this one takes the cake. President Rodrigo Duterte won an election on the promise of, I'm going to kill thousands of drug addicts. And then later on, he said, you lawyers, you facilitate the bail of these drug addicts. You're next. And suddenly, lawyers began dying all over the country. During his term, 6 years as president, 67 lawyers were killed. Some of them are human rights lawyers because in the end he said, oh, you human rights. He doesn't say you human rights defenders. He calls us human rights. You human rights. If the addicts will continue with their crimes, you're responsible for it. And many thousands were killed during his term, but many also, hundreds of activists, human rights defenders were repressed and killed. Some were imprisoned, some were deported, like Sister Patricia Fox here from Australia, who was helping out the farmers, and Duterte said, no, you're a foreigner, you get out of the country. So she was deported too. We were sorry, we failed you, sister. I mean, your lawyers were not able to win that case. But that was the time when President Duterte was there. So in 2017, a lawyer, Jude Sabio, files a case in the ICC against President Duterte for mass murder at the time that he was mayor of Davao. Later on, media reports said he withdrew it. But then, after that, Fatou Bensouda, of the prosecutor of the ICC, said, we are now starting the preliminary examination of the situation in the Philippines. Notice that date. It becomes very important later during the debates on the case. In 2018, the families of the victims of extrajudicial killings came to us and said, look, can you help us file a case against President Duterte here in the Philippines? And I remember that day, and I said, no, I'm very sorry, no. Why? For two reasons. First, the President of the Republic of the Philippines can claim presidential immunity. Under our jurisprudence, the President is immune from civil and criminal suits. So I said, it will be dismissed by the courts the moment we file it. The second reason is President Duterte practically controls everything. The police who will investigate this case is not going to investigate genuinely. The prosecutor won't dare prosecute President Duterte. And even the judiciary would be afraid of him. After all, President Duterte took out the Chief Justice of the Supreme Court because she disagreed with his drug war policy. Can you imagine taking out the Chief Justice of the Supreme Court? not even through impeachment, which is required by the Constitution. He used quo warranto, a new case, a new way of ousting a Chief Justice. So I said, look, maybe, now I remember Melbourne University, and I said, maybe we can try the ICC. And they said, could we get justice there? I don't know. I don't really know. But maybe, at least, we can do something. So they said yes. And 3 young lawyers helped together. There were 4 of us, to Christina Conti. She's a young, vibrant, very, very articulate lawyer. Katerina Pangahuban and Angelo Guillen helped draft the complaint. I insisted on 2 things during the time. I said, first, the figures we're going to use must be the ones used by the police or admitted by the police. At the time, human rights groups are saying about 15 to 20,000 were killed by 2018. Later on, it grew up to 25 to 30,000 killed. But I said, that will be an evidentiary stumbling block because we need to prove that they were killed by the police. Why don't we go for what the police admits? At the time we filed it, it was 4,117, if I remembered it right. Later on, it grew, and we kept on filing supplemental pleadings until it reached the latest figure of the police, 6,252 killed. And I said, look, 6,252 deaths is still one too many, so we'll use that figure. Otherwise, we get waylaid in the discourse, like, oh, it's 30,000, oh, how can you prove it? At least this one is admitted by the police. The second thing I insisted in the complaint was that it must include other inhumane acts. Of course, the two cases filed against Duterte was crime against humanity for murder, and also crime against humanity for other inhumane acts, because I said, look, these people were not killed, but they suffered a horrible fate. They were raped, tortured, imprisoned. They were not killed, but still, it's a crime against humanity. So those were the 2 cases filed in 2018. President Duterte began attacking the ICC, you monkeys, and so on. And the victims, of course, why did you file there? You are, foreigners, whites, he called them. And the lawyers, of course. One of the lawyers who drafted the case, the complaint, was even attacked in the parking area, and he was stabbed with an ice pick in the head. And ostensibly for robbery, but they only took the laptop containing his case folders. Oh, we were, of course, attacked, trolled, and, charged with anything. Human rights lawyers, of course, are being, victims of this for a long time in the Philippines. In fact, during the reign of Duterte, 3 human rights lawyers from our organization, the NUPL, were killed, shot to death by unidentified assailants, just like the drug suspects that Duterte killed. So he attacked, and then on 2019, of March 17, the Philippine withdrawal from the ICC became effective. That's another nodal point in the story, 2019, because it became a part of the debate when the prosecutor in September 15, 2021, asked the pretrial chamber, I'd like to start the investigation of the situation in the Philippines. That became an issue because later Duterte will said, you cannot start an investigation after you have withdrawn. But let's go to that later. So November 21, the Philippine government, the pretrial chamber allowed the investigation. The government said, can you defer the investigation because we are going to investigate the cases? The prosecutor deferred. 3 months was the first ask. And we're saying, look, 3 months is too long, But he deferred the time. It was canned by the time. And later on, another 3 months, another 3 months. Practically, the prosecutor deferred the case from 2021 to 2023. It was only in 2023 when the prosecutor said, look, 52 cases, because the government submitted 52 cases after so many deferments. Thousands were killed, and you're investigating 52 cases, and many of them are administrative cases, not even criminal cases. So the prosecutor probably exasperated and said, oh, we'll just file this case now. Went to the pretrial chamber, asked for the resumption of the investigation. Government of the Philippines opposed it. They're still claiming complementarity at the time. For those familiar with the Rome Statute, complementarity principle is very important because it says that the ICC has no jurisdiction over the case unless the state party in this case, or the state where the crimes are committed, is genuinely unwilling or unable to genuinely prosecute or investigate the case. And the Philippine government says, oh, according to the complementarity principles, we will investigate the case. But in the end, the prosecutor said, no, you're just delaying this. So files a case with the a request with the pretrial chamber for the investigation. Government, of course, opposed. They lost the case. Government goes on appeal. Appeals chamber of the ICC, we won again. The appeals chamber said, no, the investigation must continue. But note, in the decision of the appeals chamber, there were 2 dissenting votes. 3-2. Meaning to say, 2 justices believe the ICC has no jurisdiction over the case of Duterte. We were really worried there. That's why, for those interested in having, this is now a research issue in a sense, because this is the first time in history, or at least in the ICC, that jurisdiction was questioned after withdrawal. So there was a case of Burundi where they also withdrew, but the ICC said, look, we already had the investigation before the effectivity of your withdrawal, so it continues. While in the case of the Philippines, the investigation only was requested in 2021. After 2019, the withdrawal became effective. So now they voted 3-2, and the investigation continued. We kept on pressing human rights advocates, academics, and lawyers, and so on. The ICC, when is the arrest going to happen? And we becoming frustrated and probably hopeless. I had to explain to the victims, their son and their daughters were killed in 2016, 2017. Can you imagine that? It's 2025, 2024, now it's 2026. And no, nothing's happening with the ICC. So in the end, but one fateful day, our waiting paid up. March 12, this year, 2025, President Rodrigo Duterte was arrested, brought to The Hague, and imprisoned there. So what is the stage now of the ICC? Confirmation of charges. It's different from the Philippines. I don't know in Australia, but in the Philippines, once the prosecutor decides to file a case against you, the prosecutor files the information in court. In the ICC, the prosecutor will have to ask the pretrial chamber to confirm the charges, and if the pretrial chamber confirms the charges of crime against humanity, that's the time trial will start. You cannot have trial unless the charges are confirmed, and which is the current pending case now. President Duterte is claiming now that he is unfit for trial. That's why he says, my memory is bad. And we're saying, look, if you can't remember you placed your keys this morning, all of us here have the same problem. It doesn't absolve you of any. But then he's arguing that, and it's still pending. And I'm even saying, look, we aren't even on trial stage yet. We're on pre-trial stage. So how can you claim unfit for trial? There's no trial. Once the charges are confirmed and there's trial. But President Duterte keeps on delaying the trial. Motion upon motion upon motion. Our fingers are now very stiff because we have to type all this pleading. motion. Motion to disqualify the prosecutor, motion to disqualify the judges, motion for interim release, motion to suspend decision on interim release, motion to reiterate the decision on interim release, motion to disqualify the doctors who are going to decide whether it's fit or unfit for trial, motion upon motion on jurisdiction, and so on. I mean, he didn't want to avail of his right to speedy trial, like most innocent people do.
Yeah.
If you're in prison, you want a speedy trial so you can get out of prison. But no, he keeps on motion. And until now, we're in the pretrial stage. So that's the stage we have now. Oh, just it's on impunity, but I won't discuss that, except to say that impunity in the Philippines is scourge there. Not just under Duterte, but in previous, I mean, during time of President Marcos, of course, until so many presidents. Impunity is simply put, when people commit crimes and get away with it. I mean, that's impunity in a basic sense. In the Philippines, we have one of the worst forms of impunity when people commit crimes because they know they can get away with it. And that makes it horrible. So that system of impunity where you threaten the grassroots level, you threaten the victims and their families, and they won't file a complaint. That's impunity in the grassroots. The prosecutor will not file the case, the police will not investigate the case. That's impunity in the investigation level. The prosecution will not file the case against the human rights perpetrator, then that's prosecutorial impunity. I mean, the prosecutor, if you kill your neighbor, the prosecutor will file a case against you tomorrow for murder or homicide. But if the accused is a colonel or a general or even a sergeant, then the prosecutor becomes disabled in prosecuting the case. And of course, judicial impunity in the judicial level. So basically, but what I'm just saying is this: the ICC is not the panacea, it's not the solution to our problems. We need to have social justice reform, now justice system reforms in the country. But for now, we're not having that. ICC is a recourse. Just to clear the point that we need to do some reforms in our own particular country rather than rely on the ICC. So, what is the issue now? President Duterte wants the case dismissed because the ICC has no jurisdiction because the Philippines has withdrawn. And we claim, there is Article 127. Now let's go to the legal issues. We claim that the Rome Statute contains Article 127, which the first paragraph practically allows any member of the ICC to withdraw. It says, well, you can withdraw anytime if you want. But that's paragraph number 1. But paragraph number 2, I'll read it. A state shall not be discharged by reason of its withdrawal from the obligation arising from this statute while it was a party to the statute. And the Article 127 added, nor shall it prejudice in any way the continued consideration of any matter which was already under consideration by the court prior to the date on which the withdrawal became effective. So that was our argument. So ICC has jurisdiction. The matter has already been considered by the court way back in 2017 when the first case was filed, and in 2018 when we filed the case, and also in 2018 when the prosecutor said preliminary examination of the situation in the Philippines is being conducted. So it's under consideration. Oh, but this time around, the lawyers of Duterte are no longer the lawyers of the Philippine government. They said, and this is really something that if I had time, I'd like to research on this very well someday. And they said, no, the matter is not being considered by the court. The prosecutor is not the court. And the matter that is being referred there does not include preliminary examination. It includes the moment the ICC investigates when the court is involved. But as long as it's a preliminary examination of the case, it's an internal matter on the part of the prosecution. So of course, we argued that's absurd. A preliminary examination is still a matter before the court, and the prosecutor is part of the court. But that's what they argued. So there was a dissenting vote, and the dissenting vote said the court's jurisdiction must be triggered before the withdrawal has become effective. That's what the two justices of the appeals chamber said. Put differently, once the state's withdrawal has become effective, the prosecutor can no longer open an investigation. So that's now a legal debate among legal luminaries out there and academics for that matter. We consider, said the two justices, that the prosecutor's preliminary examinations are not a matter under consideration by the court within the meaning of Article 127, and that a situation is only under consideration by the court once a pretrial chamber authorizes an investigation. So now Duterte claims, when did the withdrawal become effective? 2019. When did the investigation start? 2021, 2 years after the effectivity of our withdrawal. We argue, no, it started with the preliminary examination when we filed the case, but of course, we won there, but there were two dissenting votes. The second is, Duterte is now using Article 12 for the international law academics here. Article 12 of the ICC says, there is a precondition for the exercise of jurisdiction. Duterte says, there is a difference between jurisdiction and the exercise of jurisdiction. What does jurisdiction mean? Is crime against humanity within the jurisdiction of the ICC? Yes, because it's listed as one of the statute crimes. Is the crime committed within the period where the ICC has jurisdiction? The answer is yes, because it was committed at the time that the Philippines was a state party of the Rome Statute. Therefore, it is within that jurisdiction. However, Duterte argues that that jurisdiction is different from the exercise of jurisdiction. According to Article 12, as they say, you can only exercise jurisdiction in case of Article 13, which is about how the case is started. The court may exercise its jurisdiction if one or more of the following states are parties to this statute. The state on the territory, which is the Philippines, of which the conduct in question must be a state party at the time of the exercise of jurisdiction. Oh, so that's a new argument that they're using. And at the time when the investigation is being discussed in the pretrial chamber, whether to allow the prosecutor to conduct investigation or not, at that time, the Philippines is no longer a member of the Rome Statute. So they said, yeah, you have jurisdiction over the crimes, but you no longer have jurisdiction at the time you are going to exercise that jurisdiction. For us, it's absurd. We argue, no, this means that when you exercise jurisdiction, the Philippines must be a state party at the time the crimes were committed. But they argue otherwise, so that's the gist. So now, they have appealed again. On May of 2025, after Duterte was arrested, they appealed. The part of their interim release motion was a challenge to the jurisdiction. So they claim the same thing. The prosecution now argues. The prosecution avers that the court is lawfully exercising its jurisdiction over Mr. Duterte as the Philippines was a state party at the time of the alleged commission of crime. That's the very real essence of Article 12. Not at the time of the exercise, but at the time the crime was committed. So, and it is satisfied at that time rather than at the time the court exercises jurisdiction. So that's a debate. Second is, the prosecution submits that Article 127 of the statute precludes a state party that withdraws from the statute from depriving the court of the exercise of its jurisdiction if the matter was already under consideration by the court before the withdrawal becomes effective and the initiation of the preliminary examination in this case is sufficient is sufficient for the matter to have been under such consideration. So it's a debate now whether it's a preliminary examination or investigation. The lawyers of the victims and the office of the public counsel for the victims, we argue the same thing as the prosecutor. But what differentiates our argument is that we added the issue of impunity and justice as a public purpose of the ICC. We say that the victims in this case were greatly concerned about the proceedings coming to an end if the defense challenge were successful. If they win this, Duterte goes free. And that concluding that the court could not exercise its jurisdiction in the current case, we say it would uphold impunity, deprive the victims of the justice they so richly deserve. So we put in the policy aspect of the ICC in our argument and indicated that they could face threats. We could face threats from Mr. Duterte and his supporters if he were thereafter returned to the Philippines. So the victims were saying, look, if you free him and he returns to the Philippines, you better say goodbye to us now because he's going to go on rampage. It's good that, that the ICC denied his request for interim release. Said, oh, the jurisdiction, the ICC will say something about jurisdiction, but said, look, we can't release you because one, you're a flight risk. You're a flight risk, you have the resources, you have the motive. You have the motive not to attend trial. Why? You always claim we have no jurisdiction over you. We kidnapped you. That's what you say. And now, you have the motive not to attend trial because most likely, serious, that's what the court said. You have a serious charge. We say more openly, no, you know that you're going to get convicted, so you're not wanting to return to trial. Second is, you will interfere, which is the rule under the ICC, you cannot be released if you will interfere with the investigation and threaten the witnesses and the parties. And that's what the court said. No, you will threaten the entire investigation and proceedings if you're released. So you cannot be released. And the third is you can continue committing the crime, which is a requirement also of the Rome Statute before you're released. He promised during the elections in 2025 that, was it 2025? Well, he promised, 2025, I'm getting old now. 2025 election, he promised, if I win as mayor of Davao, I will repeat the same things I did. And more. And he won, except that he was arrested later on, but he won. So the chamber said, no, we can't release you. But now let's go to the resolution of the jurisdiction issue. The chamber, this is the decision of the pretrial chamber. The chamber recalls that the provision of the statute are to be interpreted according to their ordinary meaning in their context and in the light of the object and purpose of the treaty in accordance with Article 31 of the Vienna Convention on the Laws of Treaties. Lex specialis. So this is what the court did. Oh, in the Vienna Convention will be the one used to interpret your position. So they used the Vienna Convention in this case. And the court said, a treaty shall be interpreted in good faith in accordance with the ordinary meaning given to the terms of the treaty in their context and in light of its object and purpose. Object and purpose becomes important now using the Vienna Convention on the Law of Treaties. And the court said, the ordinary meaning of the word matter is clearly broad enough to incorporate the subject of preliminary examination. So you cannot say, oh, it's only investigation, not preliminary examination. That's the definition of matter. No, court said no. If you say matter, it's any matter. And the subject matter at the time is that there is a situation of killings in the Philippines. So preliminary examination is already a matter under consideration of the court. What about the court? The second part of the story, where was I? Yes, sorry, the court. Noting that the court is capitalized. Oh, the court used this. So it's a very good, if somebody can research, the court said, the word court is capitalized in the Rome Statute. Therefore, its ordinary meaning is better defined by reference to the specific institution, the ICC. And because it refers to the institution of the ICC, that includes the prosecutor. Because the ICC, the court is expressly stated to be composed of 4 organs, including the prosecutor. So when the prosecutor conducts preliminary examination, it is already a matter before the court. So that's how the pretrial chamber did it, and the chamber observes. But this is where it becomes a little tenuous, because the pretrial chamber added, we call it in the Philippines, I don't know if it's the same here, pro hac vice. We call it pro hac vice in the Philippines. It means the law of the case. Attorney Panyero, you would know that. Pro hac vice is a lawyer in the Philippines. What did the pre-trial chamber say? The chamber observes that in future situations, it may not be that every preliminary examination would encompass a matter which was already under consideration by the court within the meaning of 127. A finding on this regard is not automatic exercise and needs to be approached with utmost caution to avoid any abuse. Each situation will need to be analyzed on its merit. So my interpretation of that, this decision is not a precedent. The court is saying, well, now we say it's part of the court or any matter, but in the future, maybe not. So that's why we really are a little bit nervous, because we know that President Duterte will raise it again. They'll find a way to raise the issue of jurisdiction again, even if it's prohibited by the Rome Statute. They will raise it again, especially maybe during trial, they'll try to raise it. And because of that decision, the court is saying, no, it depends on the situation. So yeah, I guess we need to beef up our ammunition here. And last point, now the court argues on the basis of purpose and objective and policy. The court said, as argued by the Office of the Prosecutor and the Office of the Public Counsel for the Victims, it is clear from its preamble that by ratifying the statute, state parties affirm that the most serious crime of concern to the international community as a whole must not go unpunished. So are determined to put an end to impunity for the perpetrators of this crime and thus to contribute in the prevention of such crime. That trumps all the argument, the legal arguments. The court said, well, that was the purpose of the Rome Statute. To end impunity, grant justice to the victims. Now, you're going to want us to set you free? How does it help the battle against impunity and justice for the victims? It would be entirely against that object and purpose to interpret Article 127 of the Rome Statute to enable a state party to evade its responsibilities under the statute by merely depositing a written notice of withdrawal from the statute once it's discovered that alleged crimes committed in its territory or by its nationals are being examined by the prosecution. So what the court is saying, look, if the prosecutor announced, we are having a preliminary examination on the country of A, what A does is just to withdraw, and A will say, the dictator will say, you have 1 year. You better start your investigation, because if you will not investigate within that 1 year period, I'm free. So that's what the court is saying. So all dictators, all human rights violators will have to do is just file a withdrawal. And I also argue, although this was not argued by the prosecutor, I argue that this is practically a statute of limitations. Under the Rome Statute, what's it in Australia say?
Yes.
Prescription. In the Philippines, we call it prescription. There are no statute of limitations for human rights atrocities like crimes against humanity. Meaning to say it's 10 years, 20 years, you can still file a case. But this time, if we agree with the Duterte defense analysis, then we're practically imposing a 1 year statute of limitation. You better file it in 1 year, otherwise you cannot try it anymore. There's an additional argument on our part. And so far, we've carried it. to find that the preliminary examination in the present case does not encompass a matter which was already under consideration by the court prior to the date would go directly against the object and purpose of the Rome Statute. If we allow you to do this, then we've practically trampled on why the ICC was put up in the first place. So that's what the court said and denied the motion. So I guess that's the Supreme Court, Philippine Supreme Court decision, where the Supreme Court said that our obligations are continuing. But that's the lay of the field now. And we hope that if they raise it again, we will be able to pastor stronger arguments to convince the court once and for all to say that no, you cannot interpret it as a preliminary examination, because otherwise, as the court said itself, otherwise all dictators will just simply withdraw their case. So it's a long road to Hague. It's actually a long road from Rome to Hague. But actually, that road, for me at least, started with Melbourne, Rome, and Hague. So, and I'm glad in that long journey, you were all with us in the Philippines, the Melbourne Law School, Tim and Sarah, and all of you friends, you were there with us in that long journey. And Australia is one of the countries that you sort of accept universal jurisdiction. And I'm glad that you do it here. It's good to travel that road with you. As I said yesterday, the struggle for human rights transcends borders, transcends national boundaries. It's not a Philippine thing, an Australian thing. It transcends boundaries. The struggle for human rights is a borderless struggle. And we must wage that struggle together against those who commit human rights atrocities whenever and wherever it is committed. Thank you.
For those of you who don't know me, my name is Alison Duxbury. I'm a professor here in the law school, so one of Sarah and Tim's colleagues. And it is a great pleasure to be closing off this speech at the end. But first of all, quite thankfully, we have time for questions because I know that there will be lots of questions given the depth of Neri's conversation and discussion so far. And what I thought was really important about your discussion is the way that you move between quite broad concepts of the idea of international criminal justice not being a panacea, and also knowing that there have to be other types of justice measures available for victims, as well as, so moving from those sort of quite broad concepts to very technical issues regarding the Rome Statute, Articles 12, 13 and 127 too. So, you know, greatly appreciated, an incredible discussion. And I know that Melbourne Law School is very proud to have been part of that journey that you talked about, that went from the Rome, Hague, Manila and also Melbourne. Yes. I'm sure there's a title for a book there somewhere, but we'll leave that for another matter. So with no further ado, I would like to open up for questions. I would like to just remind people that this is being taped. So your question will be on the tape. Okay, and I'll take two at a time and then I'll open it up again. So you, sir, and was there someone else who wanted to, and you know, yes. Okay, so I'll take two to begin with. Thank you.
Mayang hapon. Just so the Duterte's presidency was between the 30th of June 2016 and the 30th of June 2022. Given the jurisdictional issues, and you mentioned the 1 year effectively limitation period, I'm assuming the answer to this question is no, but does it cover any instances of extrajudicial killing post the withdrawal of the Philippines from the Rome Statute? And what I'm interested in is your office, the office of the for the victims. What has your advice been on how victims can find justice when, unfortunately, those instances of extrajudicial killing fall outside of that time limit that you mentioned?
Okay, thank you.
You take one more. Thank you.
Thank you, Neri, for your amazing presentation. My name is Lisa from Indonesia. So the reason why I interested in this workshop because I really want to learn how the Philippines succeed to arrest the Duterte. Because to my knowledge, Duterte explicitly stated that he learned or was inspired to do the extrajudicial killings by the former President Suharto, because you ever heard like in Indonesia in the 1970s or 80s, there's like a Petrus mysterious shootings under the Suharto regime. And now Suharto was dead. We have another human rights abuser and now becoming our president, Prabowo. And Prabowo allegedly, with the like a Caracas massacre in East Timor. That time is the Timor as a part of Indonesia, and also with the riots in May 1998, and also the student disappearance in Indonesia in the 1998. And I think there's a lot of human rights incident like in West Papua that Prabowo was involved, allegedly was involved in that. So my question is, what is your advice to Indonesia, especially for the human rights lawyer, to maybe learn from these cases of the Duterte in Philippines? Because like when you mentioned that our former Abu Rahman Wahid rejected the notion Indonesia to ratify the Rome Statute, as far as I know, the other reason was because Indonesia is really afraid of the foreign interference in the sense of the criminal proceedings. And also that because after the Reformation, we have this human rights court and we have the ad hoc judges for the human rights cases. And I think the last cases was 2 years ago deciding on the Panyai cases in West Papua. So I think maybe the government of Indonesia is thinking we are capable to manage and to handle our own human rights abuses. But the thing is, until now, it's very limited cases was brought to the human rights court in Indonesia. Also, we have the, like the limits on the number of the judges, something like that.
Yeah.
So what is your advice?
Yeah. So yeah, three questions. The first question is, can extrajudicial killings outside, after the withdrawal be under the jurisdiction of the ICC? The answer is no, of course. Even the killings committed within the time when we were members of the ICC is being questioned. Second, what is your advice to the victims, and what is your advice to Indonesia if they want to have it also ratified? Well, will I go to the Indonesia first? Actually, even when Estrada signed it wasn't because of his adherence to human rights principles, I think. After all, he launched a major campaign in Mindanao, and many, Muslims died there. He was ousted for corruption, so one detailed reason is that we were campaigning for the ICC and it was Christmas, and some of those campaigning for the ICC said, Neri, you never went to Malacanang to lobby for the Rome Statute. It's your turn now to lobby for it. That was December 24. So for Filipinos, oh my God, I have to stay here. Dean Raul Pangalangan was my dean in the College of Law. He taught here. He was one of those who said, Neri, you stay and follow up Malacanang. So I follow. Malacanang calls me later in the end, about 26, says, could you draft a legal memo on why the Rome Statute should be signed? And 2 pages, font 14, double spaced. So I was thinking, this is for the president, right? Because President Estrada was known not to be,
Why?
he was known to be dense. Anyway, drafted it and no, submitted at 6. In the end, I never thought, it would be approved because it's 6 p.m. And then a cabinet member tells me, no, Neri, President Estrada's cabinet starts at 12 midnight with a blue label and, So, so next day, Malacanang calls me and says, Attorney, I wasn't a congressman then. Attorney Neri, I would like to inform you the president signed the Rome Statute. So, and now it's going to be deposited in New York. Was that the reason? No, that was not the reason actually. The real reason was this. At the time, huge rallies were being undertaken in the Philippines because Estrada was caught with corruption. So maybe, in fact, it led to his downfall 20 days later. And he was thinking, if I give in to this, maybe it will pacify them. It was at his weakest point. So in the end, I think it was the mass movement, the people's movement, that really forced Estrada to ratify the Rome Statute. So it's not because a cabinet member said you draft a legal memo, it's not a lawyer drafted a legal memo. No, it's not that. It's the fact that people were actually, can Indonesia do that? Yeah, maybe you can also. I heard your big rally a few months ago about corruption in Indonesia. So, we have the same thing in the Philippines. It's called pork barrel by the legislators. So, yeah, now what is the advice to the victims? As I mentioned, the basic principle always is the framework. There must be justice system reform in your own country. We cannot rely for justice from an external force, an external court, because look, they died 2016, 2017. The sons and the daughters is 2026 now, almost 10 years later, and we're not even on trial. It's not. Should not happen. A local justice system should be able to afford justice to the people of the Philippines as speedily as possible. And that social justice reform and justice reforms, again, going back, must be through people's action again. Is it an academic way to explain how to reform society? Not really. It's true. It's the truth. We all managed to win issues like this through a people's action. EDSA 1, Marcos was overthrown by millions of Filipinos. EDSA 2, Estrada was overthrown by millions of Filipinos. Most of this battle were by the actions of the people themselves. That will work that worked for the Philippines. I'm sure it can work for Indonesia. Now, pending that, is there something we can do? Yes. You're not going to wait for people to move, but it is important that we do things like this, making people aware of what the ICC is about, universal jurisdiction. Look at what happened in countries without ICC. At least we can argue that way in academic forums, in our articles and treaties. So, yeah, I'm sorry to say, but lawyers like us cannot solve that problem. It's beyond our capacity. It has to be undertaken by the Indonesian people, the Filipino people, to have justice system reforms in their particular country. And what we can only do is to support such efforts for justice system reforms. Thank you. Thank you.
It certainly demonstrates the importance of diplomacy as part of the equation, as well as the role of people in parliaments.
That's correct.
Yeah.
You see, during the time when the law was passed implementing the Rome Statute, it is always a comprehensive thing. We deployed comprehensive thing. I'm a lawyer, so I said the arena of battle is the Korte. In the Philippines, I always say to people, three case, Korte, Congreso, Calye. Meaning to say the battle must be waged in the courts. Of course, we have to, and the executive, we need to convince the diplomacy, as Alison will say, other countries to also fight for. In fact, the extrajudicial killings to a large degree tapered off during the time of Duterte, tapered off, not really eliminated, went down because of the international community's condemnation. And of course, Congreso, meaning if you have a chance to file a law that, will amend something like the Rome Statute, you file it in the Congreso. But of course, there's always the calle, which symbolizes people's protest. Calle meaning streets. So yeah, I guess that should be undertaken. And in the approval of the Rome Statute, a lot of diplomatic efforts were done. Last 2 weeks ago, in fact, there was a meeting of the ASEAN Parliamentarians for Human Rights. It's all parliamentarians, and I was one of the speakers. So we had to campaign with them, and they're very agreeable that Southeast Asia, we must convince our respective governments to also sign the Rome Statute. Yeah, so it's a combination of that.
Take a question. Yeah, and we've got one over here. So if you could ask your question, and if you could ask your question, perhaps keep it as short to the actual question.
So I'm hapon, sir. I'm Toby Valenzuela. I'm a JD student from Melbourne Law School, but I'm from the Philippines. Before I get to my question, Dean Tony Lavinia says hi.
Oh, the Dean, yes, of course.
Then, so as far as my question goes, sir, so you mentioned the history behind the Estrada administration signing the signing the Rome Statute, but then how after Gloria Arroyo took over 20 days later, she basically kept the treaty from the Senate. Would you happen to know any sort of dynamics as to why there was such a marked difference between the two administrations in terms of their stances on records?
Yes. Well, basically, Estrada and Arroyo, actually, in terms of human rights records, there's no substantial difference. The only reason was at the time Estrada signed the Rome Statute, as I mentioned, he was at his weakest stage. And he was going to be deposed actually 20 days later. So that, I think, was a major factor. The second is Arroyo. Arroyo refused to transmit it to the Senate, right? So it doesn't become effective. We had to go to the Supreme Court. We challenged it with the Supreme Court. And I think some of us human rights lawyers went there. Harry Roque was there. So you don't know Harry Roque, but all the Filipinos know him. And we challenged it, and we said it's a mandamus petition. Meaning to say, we're saying, look, the office of the president signed the treaty, not the person, not President Estrada. And the office of the president, now under Gloria Arroyo, must transmit it as a matter of ministerial duty. But the Supreme Court, we lost that one. The Supreme Court said, no. It's always discretionary on the part of the president because foreign policy is a discretion of the president. And we cannot order the president to transmit it to the Senate. So that's why I began to focus on the statutory implementation of the Rome Statute. Because I said, we're going nowhere here. The president doesn't want it. I mean, she stayed for a long time. She left the presidency in 2010. Can you imagine? It was signed in 2000 and 2010. It was only in 2011 that it was transmitted. Yeah, may hapon. Dagang kaig mga Bisaya dire. Yes, please.
Hello, my name is Benjamin Martinez Ria. I'm an international student here studying law as well. During the arrest of Duterte, there was a lot of controversy with the matter of how he was arrested. Yeah. And there's a lot of interpretations of how he should be put in a court in confidence, wherein some have interpreted it as he should be put to the Philippine Supreme Court first before being put to the ICC. And I think there has been recent developments of regulatory or legislative changes on putting more barriers on arresting people and sending them to the ICC. And I think there's going to be a great difficulty on the next arrest, especially towards one of our senators.
Yes, legally, sorry.
What are your thoughts on this?
Yeah, that was the issue there. President Duterte, through the Interpol, was He arrived in the airport, and the chief of the police, Philippine National Police, said, "These are your Miranda rights. You have a warrant of arrest, Mr. President, Mr. Former President. We're going to arrest you." Duterte said, and then he was whisked to a plane and then left. Issue under Article 59 of the Rome Statute, it says that the state party must bring that person arrested to a judicial authority for confirmation of the identity and etc. So he wasn't brought there. So that was the issue raised by the Duterte camp. When I was interviewed by the media there, I said, look, that's, in the first place, that's for state parties. The Philippines have withdrawn. So technically, Marcos could say, look, you ICC, you requested me to arrest him. I arrested him. Now you're requesting me to bring him to our courts? I'm not your member. I'm just a party who you requested. I fulfilled that. It's not my obligation to bring him to the court. Can Marcos say that? Yes. Because the Philippines no longer state party. So that was being used. And that's the problem of President Duterte now, because he will say the Rome Statute is not applicable in the Philippines. This is, you have no jurisdiction, etc., etc. But he turns around and say, you should have followed Article 59 of the Rome Statute. So if it's convenient, they will say, you should have followed Article 59, but if it's no longer convenient, he said, So that's basically the discussion there. But the problem of President Duterte legally in the Philippines is this. Republic Act 9158, which we approved in 2009. That law, the Philippine Act on Crimes Against International Humanitarian Law, the one I mentioned, implementing the ICC, it has a section there, Section 48, which says that in the interest of justice, the Philippine government may surrender an accused to an international tribunal in the interest of justice. So that actually could also be used by Marcos. So he didn't go there. He didn't cite the law. He just said, look, I arrested him. I brought him to you. You take care of him. So, but legally, that argument that Marcos should have followed Article 59 of the Rome Statute and brought Duterte to the local courts, I think it will lose. And secondly, President Duterte, and through Bato de la Rosa and his daughter, Sara Duterte, actually filed a petition in the Supreme Court to stop the arrest. Unfortunately for them, the Supreme Court did not issue a temporary restraining order, so he was whisked away because the Supreme Court didn't. Did the court attempt to do that? I would like to think so. Of course, the Vice President is filing a petition in your court, and you're asking that you restrain the arrest of the former president. I think the court considered that, but then the court did not issue the restraining order. So Duterte was actually brought to a judicial authority, which unfortunately for him did not issue or restrain the arrest of Duterte. So I think the arrest was legal despite the absence of those requirements as argued by the lawyers of President Duterte. Thank you.
The question here, I think you're the only one at the moment. So,
Philip Ablett, sociologist who studied the Philippines, the churches under Marcos. And look, I'm really mindful of what you've said of the primacy and politics of the people's movement being the most important driver in these matters. But I did want to ask you just a bit more a political assessment, I suppose, of what's been the role of the current administration in this process? Letting go, yes, but was it a moment? Is it a matter of, I suppose, the intra-elite rupture and conflict? And was Marcos at a weaker moment or weaker stage in his conflict with the Duterte clan? I'm curious.
Yes, a very good question, Professor Phil. Yeah, I would like to think that all of us were a factor in the arrest of Duterte. I mean, all this, international community, condemning the killings, the domestic campaigns of human rights groups, Migrante Australia. I'd like to think that it contributed to that. But did this rupture between the Dutertes and the Marcoses contribute to that? I would be untruthful if I say it didn't. It did have an impact. If the Dutertes and the Marcoses were still together bedfellows, it would have been difficult. But President Marcos now sees 2028 as a very important date. It's a presidential election. And so far, there are two candidates. One is a Marcos, one is a Duterte.
Yeah.
So I guess in that sense, that explains it. Yeah, I would like to say, no, it's the people, we were active. Yeah, but we have to recognize the fact that that rupture between, how do you call it? The elite.
Intra-elite.
The intra-elite rupture was also, of course, contributed to that.
Thank you.
Thank you.
Could I ask a question? We're focused on the trial involving Duterte. There's obviously were a number of people who are involved in these extrajudicial killings, not least the people who actually undertook the killing, but also those that there are other people involved as well. To what extent is there possibilities of prosecution against other people, including potentially the use of universal jurisdiction in other countries, if those people happen to travel?
Yes. First, I think there will be a new warrant of arrest, not too long from now. And I think the one who will be arrested, that's my thinking, is now a current senator of the Republic. Will the warrant be implemented now by the Marcos government? We don't know. But it's still possible that there will be a warrant and there will be another arrest. What about the others? That's what we discussed just a few weeks ago. I was saying, let's give more information to the ICC. So, the problem is President Duterte has a failing health. We don't want anything to happen to him. We want him to, because the case will be dismissed if something happens to him. But if that happens, if there are people arrested, as Alison asked, then the case can continue because there are other accused. So yes, that's very important for us that it will be. Now, that's why I was campaigning for the ratification of the Rome Statute, at least pending the justice system reforms in our respective countries, in Southeast Asia at least. But because the question of Alison, what if they go to this place? Will the ICC get them? No. Unless there's a rupture there too. But no, the ICC can't get them. Especially like Indonesia, if he goes to Indonesia or China or wherever. Yeah, so that's why there should also be a campaign from an academic viewpoint and even from people's, as Phil would say, as the sociologists from the University of the Sunshine Coast or something.
QUT now.
QUT, yeah, QUT. Say, there must be a campaign for that. For us not to give safe havens to perpetrators.
So you've come back to the ICC, but what about other countries' justice systems if they travel and there's universal jurisdiction in those countries? Because there's a possibility that they could be picked up by those countries as well and tried in their own justice systems potentially.
I think if this person travels to a universal jurisdiction country, even not a country without universal jurisdiction, as long as that country is a member of the ICC, he or she can be arrested. Depends on the policy of the country, of course, but I would like to think that if he goes to Australia will arrest him and surrender him to the ICC. I don't know, but that's a matter of policy usually. But under the Rome Statute, if you're a state party, you're supposed to cooperate with the ICC. And if a warrant of arrest is issued against that person, then you're supposed to arrest him. Unless, of course, you're the leader of a certain European country with a warrant of arrest, in which case I don't think that will be implemented by many countries. But yeah, at least in many countries, members of the ICC, this person can be arrested, especially Europe, I think. They can be arrested.
There was one here and then two. So
Yeah, maybe just jumping off from the discussion already. I think we can see with the timeline and the discussion that you've had so far that politics and aligning that politics to the processes and processes of the ICC is a big factor.
Yes.
With everything. And I guess I'm curious if there are concerns or potential issues that you're anticipating in the event that politics will misalign, especially in 2028. I mean, the confidence I can the plan that the daughter will win is very evident. So I'm just curious if there are preparations or strategies or expectations even of issues once or if that does happen, if she does win the elections.
Yes. Oh, ICC has been charged with, some political decisions in its decisions. In a particular country, will politics affect the implementation? Yes, it will. In 2028, there is a possibility that another Duterte will win. I mean, they're very powerful and rich and so on. And President Marcos is not really gaining a lot of ground. The corruption cases centered on his administration rather than on Duterte. So, yeah, it's a possible. What if it happens? Oh, well, I would like to think that the ICC doesn't care anymore, shouldn't care anymore if it's a Duterte or a Marcos president of the Philippines. The case is pending before the ICC. So the ICC will decide on the merits. But of course, I don't think there will be any cooperation on the part of government. You see, evidence is also still important in the trial. And we need access to that evidence. And really, it's difficult to get evidence now. So I guess, it will have an impact on the trial. But I don't think the ICC will say, oh, your daughter won, so maybe we can release him. I don't think the ICC will do that, but it will hamper a lot of the the evidentiary requirements of the prosecution and our, of course, requirements for that. But that would also, you see the victims' observations I mentioned a while ago. The victims are saying, we are fearful. We are fearful. So the moment a Duterte wins, I'm sure there'll be some fears on the part of the victims, the families of the victims, even the witnesses may no longer be that open to testify. I hope the lawyers will continue to be brave enough and continue the case even if Sara Duterte wins. Yes, that's the rule in the National Union of People's Lawyers where we were. We, as a matter of principle, we say we have brave clients. They deserve brave lawyers. So maybe we'll just continue plodding along if a Duterte wins and see if we can pursue human rights work despite another Duterte in office. Well, we survived Duterte. We will survive Marcos. We can survive another Duterte. Actually, we've survived two Marcoses. We can survive two Dutertes.
My question is a sort of follow-up to these with 2028 coming, Marcos versus Duterte.
Yeah.
So would it be in the interests of Marcos now to prosecute people involved in the extrajudicial killings, for example, police officers or others, as a way of embarrassing the Duterte campaign?
You're right. Actually, that's what we're saying. Why don't you prosecute them? Marcos, this is now going to the political aspect of the case. Marcos lost the 2025 election. He was an incumbent president, and 6 of his 12 senators lost. 4 senators from the Duterte camp won. And we're saying, oh, you're not a good leader if you're... And 2 from the opposition senators won. So Marcos had 4 winners, only 6 winners, so he's feeling the heat now. During the arrest of President Duterte, it generated a lot of sympathy from Filipinos. Maybe some of them didn't used to support him, but they say, oh, kawawa naman. It's really, how do you say kawawa in English?
Pitiful.
It's pitiful. It's pitiful that you a former president you arrest. So he got that sympathy, and that something is very worry. If he goes after this huge bunch of people, then he may get a backlash in the same manner that he had a backlash when Duterte was arrested. But we're saying you will not win in 2028 unless you do what Professor Tim Lindsay said. No, I say that. I was just joking. But yeah, I don't know what he will do. His policy positions are a little bit difficult to read. Marcos, the father, was very clear. I want to be president for life. And anyone who opposes that, I will kill. That's very simple. We can read him. Marcos, the junior, not so much, Tim. So, but yeah, we would be happy if he cracks down, of course, on the Dutertes. But the Marcoses have a big problem now. In fact, human rights violations continue to exist in the country. The corruption issues are centered on him. And so will he risk a war on two fronts? From the people and from the Dutertes, or he'd rather side with one over the other. So I think he's not trying to aggravate the Dutertes as much as of now. In fact, the common slogan in the Philippines, Marcos, Duterte, walang pinag-iba. There's no difference between the two of you. So let's see how he pans it out in 2028. But there's a big chance, as you asked, that Duterte will return to Malacanang.
Got a question.
Hi, Dr. Neri. Great talk. You mentioned before about the evidence, 4,000 plus cases.
Yeah.
You're using the police's case
Yeah.
files effectively. So how does, I'm remembering the South African case that was settled before it ever got as far as this particular case, where they had to show this bullet manufactured by this company in breach of using the Alien Torts, an act of piracy in breach of UN Convention, killed this person by this person with this gun manufactured by this company.
Yes.
And they collected, tens of thousands of stories of testimonies and had to demonstrate gross human rights violation. And there was a lot of legal argument about what does gross abuse mean. In your case, with 4,000 plus case files, is it, from the police?
Yes.
So is that the evidence base? The police has a record that under a program ordered by the president, we've killed this person.
Yeah.
What's the,
Yeah.
you have to gather testimonials, and how do you get the resources to do that?
Well, we need to gather testimonies. We need to gather, of course, if there are evidentiary like bullets, stuff like that. But the Rome Statute makes it a little simple. Now, what is the simple aspect of the evidentiary requirements? Under the Rome Statute, a crime against humanity has three elements. The first is widespread or systematic attack. The second is against civilian populations. Third is with knowledge of the attack. So those three elements, we can prove already, first, widespread or systematic. Of course it was widespread, from Apari to Hulo. So they say, from Mindanao to Luzon. Was it systematic? Of course it was systematic. The modus operandi was clearly a system. Two motorcycle riding man, somebody from behind will shoot, stuff like that. Complete, there's a pattern there we've established. So that's the first. The second is against civilians. Of course, they're all civilians, right? So there's no evidentiary hurdle to. Now, the most important hurdle is the third component, with knowledge of the attack, meaning to say the perpetrator was aware. I don't think we need a lot of evidence to prove that. President Duterte himself has mentioned so many times publicly, ordered the killing of drug addicts, drug suspects, killing of their lawyers, killing of human rights defenders publicly. So knowledge of the attack is there. Second is, not only did he order the killing, he encouraged the killing. I'll grant you amnesty, I'll grant you pardon, don't worry about it, go on. So I guess that also solves the evidentiary requirement there. And the third is, there was a congressional hearing, and we were there. I was one of those invited. President Duterte was invited, And that's the time when he nearly boxed the senator. He took the mic and said, anyway, I couldn't do that. But anyway, there was a colonel there, Colonel Royina Garma. She was in on the structure of the killings, and she testified. And her testimony was President Duterte funded the killings. 30,000 peso per head to 50,000, depending.
So there's enough.
There's a lot, not only that, but there's a lot. That's why the killings were in the thousands. Because one kill is 50,000. You know, there's a lot of money. You kill 10 people in one night, you have 500,000 pesos. So sometimes you're not even a drug suspect. I just need the 30,000, right? So the evidence is enough. That's why we're telling the prosecutor as early as 2018, file the case, investigate the case. But for certain reasons, they didn't. Until 2021, now it's an issue. If they only filed the investigation in 2018, then we didn't have this issue. Yeah, so, but we will still need the evidence, if ever, because they have great big time lawyers. I'm sure they will raise a lot of questions and evidence. We don't have access to the evidence, to the evidence. That's why they admitted to killing 6,252. That's our proof that it was widespread. You admitted it, so what is there to prove, right? And Duterte admitted to ordering the killing publicly, so you have knowledge of the attack.
Any other questions? Yes, Jan Lin, first of all, and then over to you.
So just to follow up on the point of evidence.
Yeah.
Because sometimes the number of casualty itself is contested. That in other atrocity, how many actually died?
Yes.
Is actually, different version, different parties, obviously for their own interest. So really two questions is, to what extent do you feel it is fortunate in a weird way that Duterte is such blatant and almost bad at doing bad things? And to what extent it is that this evidence remain a concern in other attempted prosecution of war crimes, which is ongoing in different parts of the world?
Yes. That's a good question, because in this case, it was not so difficult for us. He likes to speech, make speeches. He likes to listen to himself. The others may not be that forthcoming. That's your question, right? So I don't know. I think that's why I want to go back to how do you reform your justice system? Because the reform of justice system allows for access to evidence to the victims. I mean, that's one part, right? So I don't know. In situations like the Philippines, it would be very difficult had Duterte not been that forthcoming. The police was even so blatant about it. They admitted to killing 6,252 people. I mean, in another country, they'll probably not say, oh, we didn't do that. But in this case, the police admitted. So we use that as evidence. Yeah. I don't know. But maybe, just maybe, other than maybe if there's the ICC is there, maybe there are resources to go about it, so on. There are access to evidence and so on. Or second, there may be a political shift of a wind where the new administration cooperates and gives the evidence. But in the end, it boils down to the fact that we need to have more ideas on how to reform the justice system, whether it's in the Philippines or Indonesia or wherever, so that at least we will not encounter such evidentiary difficulties once a situation similar to Duterte happens. Marcos was a lesson. Marcos, the father, was a lesson. Thousands were killed. And in the end, how many were prosecuted? I mean, I saw my torturer. I remember my torturer. I saw him, and what can you do, right? At the time of Cory Aquino, he was a top official of the Commission of the Customs. So, yeah, and I'm supposed to be a human rights advocate. I'm supposed to be a lawyer, but I could not even file a case against him. So yeah, there must be some reforms. Otherwise, the experience of what happened to Marcos Sr. will be repeated again and again and again. Marcos got away, in a sense, scot-free. He was overthrown, yes. Major victory, yes. But he never spent a day in prison. Even Imelda did not spend a day in prison. In fact, none of the Marcoses spent a day in prison. So I guess that's the tragedy of this issue, that we need all the support we can get to reform the very justice system that we so rely on for accountability and justice for our people. Thank you.
One more question and then we'll finish up. Thank you.
Yes, perhaps jumping off, so two shorter questions. Jumping off that first one was, I know you mentioned that there was an outpouring of, oh, what a pity, Duterte has been arrested. In your own assessment, do you see that there is an appetite, even though the population is saying, oh, what a pity, our former president was arrested, bring him back. Do you find that there is an appetite from the population to perhaps not excuse that type of behavior towards low-level criminality, which in most cases that's what we're talking about when we're talking about EJK, low-level criminality and summary killings. Do you think that there is a switch in the population's attitude towards those hardline approaches? And perhaps my last shorter question, perhaps a good one to end with, I'm not sure if you've read Patricia Evangelista's book,
Some People Need Healing.
She has there's a great quote there where she says, in the first year Duterte was president, he said kill, or formations of that word kill, hundreds of times, whether it was talking about drug dealers or whether it was talking to scouts. What do you keep in mind doing this work, and you've been around for such a long time, keeps you going back to your office every single day when you might know that you might be attacked?
Yeah, well, the first question, I'd just like to clarify, there was some sympathy generated, but many Filipinos, of course, didn't support that thing like, I'll bring him back so we can do it all over again. No, majority of the Filipinos do not support Duterte. There was that sympathy, especially from the Duterte's supporters. They were able to consolidate. And of course, as I mentioned, they had a vote turnout in the last election. The opposition also had sort of a solidifying vote, in a sense that we were able to win 2 senators and some, party list groups. The Marcos weren't able to consolidate their vote. So, yeah. So there was that sympathy, but not over. A majority of the Filipinos don't want Duterte or don't want extrajudicial killings. That's not the society they want their children to live in or grow in. So that's the first. Second question, how do we keep it on? How do we survive? Well, let's go out from the academic world and go to our experience. But that has been asked of me for so long a time. And maybe you're right. This is a good point to end this forum. They say, well, Neri, you've been into human rights advocacy, for many decades now. And don't you ever get tired? And I say, well, of course, people get old. I'm now 42 years old, Tim. I'm old, very old. People get tired, we get old. But however, we have to press on, and we will continue to press on. And what keeps you going? There are many reasons why people keep doing what they're doing. Maybe because we think we're right. We think, we're on the side of what is just, right? But for me, I always mention that, especially the young students who get tired. Oh, we're doing this again. We're having another rally and nothing happens. I say there are two basic principles that kept me on during the times of Marcos and then Duterte and Marcos and so on, and Gloria Arroyo and so on. First is the principle of trust. And I've always said that trust in the capacity of your people, of the Filipino people in this case, to change society for the better. This is not our destiny. We are not destined to eternal poverty and oppression. We are not destined to Marcos and Duterte forever. So we have to trust in the capacity of our people to change the society for the better. I mean, Marcos was one of the most powerful dictators in the world during his time. He was the president, therefore he wielded executive power. He issued laws. The young ones may probably didn't know that, but Marcos issued laws, not just Congress. He issued presidential decrees. So he was the legislative. Marcos issued warrants of arrest called the Presidential Commitment Order, which was issued against me, although I don't think he knew me. I'm just a nobody from the Visayas. So he was the judiciary. As far as we know, only courts can decide who goes to prison and who doesn't. Yet Marcos, by ransom, decides who goes to prison. He was one of the most powerful dictators in the world. And yet, lo and behold, one fateful day of February of 1986, the Filipino people stood up and said, enough. And one of the most powerful dictators in the world bit the dust, was overthrown. So that's the trust that we need. That's what I say. I continue to trust. We will get it. The Filipino people can do it. The moment you lose trust, then we better say, what are we doing in this forum? We're all discussing ICC. Nothing will happen out of this. Trust is very important. That we can change the society for the better. And so the second principle is, the moment you go to the principle of trust, inevitably you go to the next most important principle, which is hope. Because you trust, therefore you hope someday we will get there. And that's what keeps us going. That's what makes human rights lawyers continue to do what we do. Of course, are we afraid? Of course we're afraid. Your colleague was stabbed in the head with an ice pick, We're not superhuman people. But because we trust, therefore we hope. And because we hope, we continue to struggle. Thank you. Thank you, Lord.
Thank you very much, Dr. Neri. And for talking to us about your journey as a human rights lawyer, as a student, and obviously as part of the Parliament. It's very much appreciated. I think that idea of ending on the twin principles of trust and hope is a great way to think about the future of human rights law per se, and also international criminal law as an area of both academia and practice. And we've already had a round of applause, but on behalf of Melbourne Law School, on behalf of the Asian Law Centre, thank you very much for coming to Melbourne, for talking about your work, and also being so generous in answering our questions about all you do. So perhaps just to finish off with one more round of applause. And thank you to everyone for coming along. Very much appreciated.